Good morning. It's April 3rd. We are going over S29 and we have Ruben here to provide some perspective. Good morning.
Happy to talk to you guys. Small group. So anybody has got any questions, since I will ask it. I'm a lawyer in Barrie. I've been practicing there for 50 years. I haven't. Our office, and I'll just tell you a little bit about myself and why I do what I do, so you understand why I'm here. I've represented indigent people. Our office has the contract to do all of public defender work in Washington County. So I've done a lot of criminal defense for indigent people, and I've also done personal injury cases for a long time. I do that for two reasons. I started doing personal injury cases when kind of followed up on the criminal work and getting clients. And I've enjoyed it, and I've been living at it. But I'm going to be careful not to take cases that are garbage or that are frivolous or not worth something. And so I'm here to talk about the concept of limited liability, protecting large corporations from liability, as is in spill. And I'm concerned about it because it's a slippery slope. And insurance companies and large corporations in many parts of the country have been very successful in limiting the ability of injured people to get recoveries. Barriers to getting into the courts, higher fees, crowded dockets, expensive lawyers. And it's every time there's some kind of opportunity for a larger corporation to kind of put up another barrier like immunity or limited liability, they kind of do that. And they say, well, it's necessary to limit insurance rates and keep insurance costs down. So I'm just going to give you an example of things that I might do. And so let's assume it's today and you're going up to Walmart with your grandma to get her prescription for insulin pills. And I'll tell you, up at the mall, it's icy on that sidewalk outside of Walmart. Walmart has an obligation to provide safe passage to their stores. It has to be reasonable care. Have a clean, just have to take reasonable care. So the manager, she comes in and she sees, oh, I got to deal with this ice, but she said, no, before I call the janitor, I'll go have a couple of cups of coffee and we go an email. I go up there, you go up there, you fall, you break your arm, you crack your head. They haven't taken reasonable care to keep the sidewalk safe. So now what happens? If they have limited liability, forget about a recovery, essentially. And I'll talk about how this bill protects them. But they're insured. So what happens is you make a claim. You've lost a month's worth of work. You've got $10,000 or $40,000 worth of medical bills. You basically laid up. You can't do what you love to do for a year, 6 months. Unless there's a pot of money to compensate you for what happens to you, you're out of luck. Who pays the medical bills? Medicaid, Medicare, Blue Cross pays the medical bills. It's a shifting thing. So you come to me and you say, Richard, I hear you do these cases. And I say, what happened? And I make a few calls. I find out that they were careless. I said, did you see the ice? And you say, well, I really didn't see the ice. It was kind of black ice. So I take the case, I make a claim, and I settle the claim. And you get the money. I get my share. And life goes on. And the system works that way. And it works pretty well. The problem actually is not enough people who are injured are able to recover. It's particularly true in medical malpractice cases. Most of the people who suffer medical injuries can't find lawyers to make the cases. Insurance companies don't pay. University of Vermont has taken the position as they don't settle cases until the very end, so the lawyers don't take the cases. So if you have a medical injury due to negligence in Vermont, you're going to have a hard time recovering. It's just another way to flop recovery. So Walmart insured. So what's going on with this bill? Let me say first that there is no legislation in this state which provides limited immunity to large corporations for personal injury. I can't find something. Well, it's not something we do. We don't give limited immunity to drivers. We want people to drive smaller, safe cars. We don't give them limited immunity from lawsuits if they have an injury, or cause an accident. We don't give limited immunity to hospitals and doctors to encourage them to give fewer expensive medical tests. It's not what we do. We do other things to encourage economies, environmental protection. We do other things. This bill could do other things to protect less salt. So I say, before you approve a bill that gives limited immunity and limits people's access to recovery if they're injured, you need to feel it's really necessary. And I don't see any justification in this legislation to do that. I looked at the testimony from the New Hampshire people, and they were asked, to this House Judiciary Committee. Their whole idea is to incentivize the snow people to use less salt. And someone said, well, do you know whether this works? And the guy says, well, no one wants to be sued, but there aren't that many lawsuits against, people who are dispensing salt. The big guys that are dispensing salt in parking lots, sue people for slipping in a parking lot, sue them for slipping on the sidewalk. I came up here, I know that it's like snow and a little parking lot out there. But I think people fall on the sidewalks. So they're not getting sued, almost very little litigation. Guy says, we use less salt because we save it. We use less salt because it's environmentally the thing to do. Sure, we would like to have them in liability. But I don't think the bill establishes that this will accomplish what they want to accomplish by having liability. There are other approaches to incentivize people other than create a system that doesn't exist anywhere else in our legislative system of laws. Let me just explain to you how this, as I understand how it works. They can't possibly create standards how snow and ice should be removed in every situation. I mean, it's impossible. What do you do today? What do you do when it's 20 degrees? What do you do if it just snowed? The standards just say, you essentially say, use less salt. Be aware of that. So I run a snowplow. I got 12 trucks. I'm taking care of the Walmart parking lot there in Berlin. It's a 4-hour course in New Hampshire. Really? This is supposed to teach me how to use less salt. I go to the course, like my guy goes to the course. He gets certified. Okay. He's not driving the truck. He may drive one of the trucks, but I got other guys driving my trucks. The law says the other guys don't have to go to the course. They just have to be instructed by the guy who did go to the course. So now it's a day like today, and it's icy at 7 o'clock in the morning, but not icy at 9 because it melts. And they said, well, we're not going to send the trucks out for an hour. We're going to wait to see if it melts. And as a result, I won't get injured. They come to me and they say, I slipped, it was solid ice. I make a claim. I'm told Reuben, Smith's. I go to Walmart to make a claim. Walmart says, well, we hired a certified dispenser of salt. it's a presumption that they did it right. And besides, there's limited liability anyway, so sorry. Why are we protecting Walmart for the area of putting up salt on their sidewalk by some company that's well intended but didn't do the right job and who's insured anyway? It doesn't make sense to do that. So some people say, well, you trial lawyers are just interested in making a lot of money. You just don't want anybody to interfere with the right to sue. And that's all I'm here. Because, I'm here because I don't like to see well-intended legislation. This is a really good bill. And nobody wants salt in our ordinance. It's a problem. But the salt is coming from the interstates. It's coming from Route 2. It's coming from, Route 302. It's coming from large, major highways. It's not coming from the sidewalks of Walmart. Maybe a bit, but doesn't justify creating a precedent and a system of, limited liability when no one has really established that it's going to make an environmental difference. I think I've talked enough. Got any questions? I'd be happy to.
At the end,
Yeah, I was just curious, the example you used of someone who came to you in reference to walking a Walmart, you asked if it was, did they see the black X letter? Was that a fictitious example or was that?
No, it's a common example because it was a hypothetical, fictitious example, but it's very common. The reason why we don't bring these cases, the reason why Vermonters don't like them is because of that expression, slip, fall, and slip.
Well, the reason I asked the question is because you said people don't slip in the parking lot, they slip on the sidewalk. So I'm just wondering, is that a hypothetical? Was that an actual case where they slipped in the parking lot?
My experience is most slip and fall cases are on sidewalks where the landlords or the store owners haven't maintained enough safety. People do slip in parking lots, but it's all about the standard of care because the parking lot owner has an obligation to make sure that it's not slippery in the parking lot. I don't think so. I mean, go up to Walmart, park 50 yards away from the store, the parking lot up there. I have no expectation on a day like this that it's not going to be slippery walking into the store. But I have an expectation is they're going to have a sidewalk, basically sanded and salted. So if someone comes to me with that kind of fall, I'd say. And the other thing is people have an obligation to pay attention. So there are a lot of these cases. And I remember picking a jury once in Washington County, and I said, what do you think about slip forward suitcases? And 10 out of 12 people said, what are you doing for January? What kind of things? Well, everybody knows about ice in Vermont. And it's true. It's very difficult to file a claim successfully unless you have really, really serious injuries and really clear negligence on the part of the property owner. And so what I think needs to happen is there need to be some kind of safety standards if there are, but there are no particular safeties. The jury will decide what lawyers screen the cases, but the jury will decide what should the land or the property owner have done. Nobody, by the way, ever thinks to sue the guy spreading the salt. Why would you sue the guy spreading the salt? It's the owner who's got the responsibility of making the property safe. So I want to step back a little bit and say, we don't give limited liability to cigarette companies. Say, well, if you only put 16 cigarettes in a pack, because maybe people will smoke less, and we're going to give you immunity from lawsuits about cancer. I mean, that's an absurd example, but no one talks like that. We don't give immunity to fertilizer companies that are spreading toxic chemicals on the fields. Get them to spread less chemicals. There are other remedies. Environmental protection laws, the regulations. So if the bill proceeds, there are other ways that can be incorporated into this bill. It's give incentives to people to use the program, but we don't even know what the program is, whether it sets standards or. I mean, I looked in New Hampshire to see if there are actual standards, what you do in one situation, supposed to another situation. If we're going to give them liability, I'd like to know what the applicators are supposed to be doing or not supposed to be doing. But we don't know that yet. And so one thing that could happen is let the agency come up with standards. Let's see what the test results. Let's see what the actual curriculum is. Let's see what they're actually teaching these people. Let's see whether the applicators will, companies will engage in this program. Let's see what motivates them. And then let's see what incentives they need to join up, rather than I'm writing the bill, I want the rivers clean, I'm gonna put in this community language. Why not? But that doesn't make it a good thing to do.
I'm wondering if you can speak to, as is in the bill, kind of the difference between negligence and gross negligence as it would apply to a case that you might see.
I can try.
I appreciate that.
Negligence is very simply the failure to take the care that you should have taken in a given situation. I mean, if you go along the highway, you're talking on the phone and you cross the center line, you have an accident. Maybe you haven't taken care that a reasonable driver would have taken under that circumstance. It's reasonable care under the circumstances. Gross negligence is one step down from intentionally hurting somebody. It's really a high burden to prove. Gross negligence means I saw this car coming in the other lane and I was talking on the phone and I didn't care. And I had to stop. It's basically, I don't care. It's very hard to prove. It's like you're hunting and you go out with a rifle, and as you know, there's a lot of people in the woods, over there, and you see something move, and you shoot. That's gross negligence.
Just blatant disregard for safety.
It's one small step down from it. You didn't intend to shoot anybody, but really you didn't give a damn if somebody got hurt. That's what gross negligence is. And very few people act grossly negligent. Most of the people who act with gross negligence are drunk. Those are the people who, most of us, most everybody, I don't hurt them. And when they see a real risk, they avoid it. Unless they're intoxicated or so. That's kind of when you see gross negligence. When your sidewalks layer ice and you know it, and you've seen two people slip on it without getting injured. When you say, I don't care. I'm not gonna, I'll do it. It's gonna melt in 4 hours. I don't care. And you actually know the people that cross this clear ice and you don't care. That's gross negligence. That's your question.
It does, and I wonder if, because currently it is the gross negligence standard that this uses for immunity, and I wonder if it would make you any more comfortable if we lowered that to a negligence standard.
It would.
Okay.
I might be confused. My understanding is gross negligence is not, you're not immune.
Right, but you are immune if it's simply negligent. My question is if immunity did not apply to negligence.
Okay, gotcha. Did you have any more? No, but I had one question, actually two questions. The first piece that is kind of throwing me off is, looking at the part on page 5, line 18, the hazard caused solely by snow or ice. And I'm wondering how this might play out in a situation where, if we're talking about a negligence claim, and let's say there's a plow truck driver who was, maybe they were texting while driving and applying salt. Obviously bad, that shouldn't happen. But while they're texting and driving, they slip, they lose control, they crash into another car that has some occupants in it, and they hurt the people in there. But if there was no snow, they wouldn't have slid and they wouldn't have crashed, and they would have carried on. So, I mean, with this line right here, that the hazard caused solely by snow or ice, is that? I'm not sure how to phrase my question, but I'm just confused, slightly concerned as to how causation gets determined for a negligence case, when we're talking about salt and ice, and immunity. Do you have any thoughts on that?
I think so. Doesn't protect anybody in that case that you just gave. The accident, if the truck driver has an accident, because not paying attention, secure the company is responsible. But the failure has to result from the way. The failure has to be not only by snow and ice, the failure to solve the problem by delay or not enough, it has an end there. So if the injury is caused both by distributing the, because of the condition of snow and ice, and because the claims didn't put enough ice, stalled down, then both. And so the claim has to be, hey, it was icy. I fell because it was icy, and you didn't put enough salt down. And if that's the claim, he's taken the course. It's basically protected. And all on is protected, not just him. No one cares about suing the guy driving the truck. That's not the issue here.
The other piece that I'm wondering, you had mentioned there are other approaches to incentivizing less salt use. Can you expand a bit on what those other incentives might be?
I think New Hampshire is the only other state in the country that has this program, that I understand it. New York has got legislation pending to develop it. One of the things that could be done is already in the bill, is that you give a presumption. If you've taken the test, if you've been certified, then there is a presumption that you are following the standards, safety standards that the state has developed. So they're supposed to develop standards. That's why you go to school, to learn what the standards are. And standards are not just use less salt, but use less salt safely. It's enough to deal with the problem. So if you do that, there's a presumption that you follow the standards, and that can be used to protect you in a lawsuit. So then the burden shifts to the person who's making the claim. I have to prove we have standards now under this bill, and they presume that they're driving the truck, you follow the standards. So there's a presumption there. So the burden has to shift. And that's not uncommon.
Can I just interject, because we dealt with something similar with another bill somewhat recently, so the standard would then shift to the plaintiff to show that the driver was not following the safety standards. Thank you.
That's what it says there on page 6. Six. And whatever that presumption is.
So in essence, it's a suggestion to remove the immunity, but keep the presumption so that the burden is on the plaintiff to prove in court that the defendant was negligent or not following the safety standards, rather than just a blanket immunity.
Adam told me not to get into this. And I'll tell you why. I don't believe that anybody's established that this program, the immunity or the changing of presumptions, will make any difference in anybody's behavior. That's the problem. I mean, it might make the guys who are distributing the salt take the course. It isn't going to change Walmart's behavior one bit. They don't care. They have national insurance plans, national programs. They're going to hire people who are doing a good job or not, regardless of this program. And we're going to give them immunity or give them a presumption of obeying standards. I don't understand why you would include the corporations on the properties in this legislation. I don't see, it's one, if you want to create an incentive, why are we, you actually believe that if you pass this bill, Walmart will then go out and hire in Vermont people who are certified to spread salt on their sidewalks as opposed to people who are either cheaper or more available or more efficient or more reliable? I wouldn't if I was running the Walmart stores up here. I'd say, who's doing the best job for the best price? And that's, I don't, that's the problem. It's a blunt tool to shift the burden. It's just a way, again, of shifting the burden onto injured people to solve problems that may or may not exist. That's why the answer to your question is, if it came down to it, yes, use the presumption instead. I'm not sure because, it would provide a level of protection to the companies. Maybe would incentivize them to do something better. I'm not convinced that, someone asked the guys in New Hampshire, do we know that this made any difference? So, well, really, the best thing was it records how much salt is being dispensed. Because if you join the program, you have to keep a record of how much salt you're dispensing. So now we kind of know how much salt is being dispensed. But, as I said, it must be 95% of the salt dispensed on the highways, not in the shopping centers. So, I answer that.
Yeah, so this, thank you. Senator Bohosky.
I have a question that no one in the room may know the answer to, but that is if all of the salt being dispensed on the highways is being dispensed by the state. And if so, why would we not simply require that the state have this certification if that's where most of the salt is being dispensed?
I kind of have to assume easily that the highway department is some kind of program to kind of get its drivers to use as little salt as safely as possible.
Yeah, I'm told by, members of the Natural Resources and Transportation that AOT has a system that's all the way down to like GPS on the bad spots that require more salt and things like that. So they do have a program that tells their trucks when to
Okay.
dispense and whatnot. It's kind of interesting. And I actually saw, I was following a salt truck on the interstate. I'm just leaving Milton. This is probably a month ago or so, and it wasn't dispensing any salt. And then it was coming up on a bridge, and then all of a sudden it dispensed salt, which makes sense because you all see the signs. Bridges freeze before roads. So
Just out of curiosity, is that automatic or does the driver get told to hit a button?
I believe they can be automatic, and there can be driver override if they,
Okay.
you know, see something in the road or things like that. That's what I've been told. It was kind of interesting.
One aside. This also includes municipal workers. In a program that's not set up by the state. The last paragraph or two. They protect municipalities. If their workers go to some program which is not described. I mean, it's kind of like, okay, we're gonna do that through. Gonna immunize the city of Barry. Or protect them, liability suits, if their drivers go to some program which is not identified other than by name. They're insured by a working Barry. They take good care of their sidewalks generally. But, why are we doing that?
That point actually reminds me of, some justifiably frustrated emails I got from constituents over the last week or two regarding another situation, in which last year we created some requirements for municipalities and said this program will eventually be created and it'll provide training. And that program still doesn't exist. And the municipalities are wondering, hey, you told us we have to do X, Y, and Z, and then we can go get training. But the training doesn't exist, and the people in the agency are saying they can't provide any guidance. So now, you know, we're in the rock and the hard place. And so that what you're saying just reminded me of that. You know, I'd be a little concerned of doing the same thing over again. This.
I just, the only point I really want to leave with. Is Vermont has a really, this legislature has, for my 30, 40 years, you know, has been really sensitive to protecting the rights of injured Vermonters and insurance, you know, it's been really good. We, you know, we get along fine. Actually, the remedies could be better than they are, but generally we get along okay. Sears was terrific at kind of watching that, you know, watching insurance companies trying to carve out stuff. This is an unintended consequence in this bill. This is not an insurance company doing this. This is not a, you know, the Chamber of Commerce doing this. This is good people trying to protect the rivers and the lakes. And they put this language in the bill. And it's a bad precedent. It kind of creates something that doesn't exist, which is to give limited liability protection, again, personal injury claims to large corporations. We don't do that. For any good reasons I've explained. And before that happens, I don't think it should ever happen. But whatever, it really needs to be proven and justified and legitimized as really necessary to solve this problem. Parking lots. I don't think they will does that. So I you know, hope this judiciary guys are front line of kind of protecting Vermonters' access to courts, protecting people's rights to recover regional situations. So that's why I'm here.
Thank you. Any further questions or comments there about?
I'm just curious, you said at one point in your testimony about no one ever goes after the contract that's applied at all. I'm curious as to why you think that, say that, because why wouldn't, you know, a landlord of an apartment building, if they get sued, they're not the ones out there spreading the salt. They have a contract with a contractor to spread that salt. They're not going around looking to see if that salt's being applied. Why wouldn't they go after the contractor that they have a contract with to provide those services? Sure.
Actually, So I had a case. Similar sort of, someone's parked next to a building with a huge, snow hanging off the roof. The snow falls off the roof, crushes the car. The landlord owns the building, he's in, they're now in 30 buildings and he's in Burlington. This was happening to me. The claim is called the landlord, said, what are you doing? You think you're going to roll up there or whatever. And he calls his insurance company. The insurance company does not negotiate stuff. It's not going to be bothered. There's no incentive for him, there's no reason for him to kind of say, well, the guy I hired, the local guy in Montpelier should have the roll up with pay him snow. But there's no reason to do that. So that's why
I don't think that may think it's snow. I don't have any contracts that have snow on the roof when I plow the driveway.
I'm just kind of using, if you're plowing this driveway or Walmart's driveway and you don't do a good job and someone slips and someone sees, they're really going to sue Walmart. Not because Walmart has the ultimate responsibility for making sure that you do a good job. Now, technically, Walmart could come back at you and say you didn't do a good job. But the lawyer is not going to be bothered unless you're a really a big guy. 30 trucks or something. But if you're an independent contractor doing snow plowing, then that suit because you didn't do a good job.
I think that else may be true.
Well, I mean, I don't mean to take you an example,
I appreciate that. No, I'm just,
but
as a landlord as well, I don't know I'd want that ding on my insurance and then my premium goes through the roof after that. So why would I not want to place that burden on the contractor that I had a contract with to provide those services?
you're both expensive. You might, like I say, I can hear you. You might. Gonna put more or less salt on the places you salt as you go to this 4-hour course. Gonna do a good job.
If I'm covered by the bill, that reduces the salt. I do properties along the river.
Yeah, well, you're gonna reduce the salt if it's economically feasible, and if you think it's gonna do a good job, that's what you're gonna do anyway. I mean,
It'll save money.
what?
It would save money. Salt's awful expensive right now.
You know what it is, better than I would be. Having gone to a 4-hour course with me, incentivize and change your practices. Probably not. Maybe you learn something to make people with that. With that decision, yes,
Is there anything else that Adam told you not to get into?
I could talk too much. That's the problem.
Everything? Any other questions? Okay, great. Well, thank you.
Thank you for your time.
Adam, do you want to add anything or?
I think we're saying,
No, understood. Mr. Chair, members of the committee, Senate Judiciary, appreciate the opportunity to be poignant. There are no Vermont safety standards that we can judge to try to engage in how they fit into changing the tort regime. And so keeping this in an orderly fashion, it's natural for us to say, what are the safety standards? This is the intersection of safety and salt. It's an intersection. There's two competing pressures here. And, we're in good faith trying to work with this committee to see if there's a way to help the environmental purpose. And obviously, as Richard's articulated, we're reluctant to wade into the tort law for circuitous route of incentives to a truck driver. And there's a lot to unpack about this. But suffice to say, Senator, your observation of the other hearing, well, the standards don't exist yet, so it's natural that we're going to be getting asked a lot of pushback on providing immunity to them. Just want to keep it there clear because there's a lot of attention around this. Immunity and limited liability, the language of that, and the notion that they're two sides of the same coin. Immunity from negligence is limiting the liability to gross negligence. So I just want to keep the advocacy conversation very well informed. And that Richard was a little light in stating that gross negligence is not, you still have a chance to get access to justice. So for this committee to think, well, we're immunizing negligence based on standards we've never seen, but don't worry, you can still go to court for gross negligence. That's not really providing access to justice for people. The gross negligence standard is very, very high. Very, very high. So
Can I just ask, we talked about the right to farm bill and or you alluded to it, I think, similar setup there, but the difference that I see is that in the right to farm bill, there were accepted agricultural practices that have been, you know, in part laid out in law and in part custom and tradition, but they're known. This doesn't seem to have that. So what made me okay with voting for that was that as long as somebody was within the scope of accepted agricultural practice, they had some immunity. But as you say here, the standards are not defined in the same way. So is that accurate?
yes, and Senator, in that case, there's property injury,
Yeah,
not personal injury.
right.
Here also interject, regarding the right to farm bill, there is also a specific provision stating that if the nuisance or the trespass is the result of negligence, there's no immunity. I think that's an important
Yeah,
point to consider.
So a couple of helpful notions. Codifying the common law, you know, Richard did kind of signal in moving a standard of care forward does help everyone, including the driver's insurance defense, because then everybody's saying, hey, I follow these guidelines. For example, in medical malpractice, the General Assembly does not say, doctor, if you follow the AMA Guide 4.0, updated version 3 at the 2025 National Convention, you are therefore then assumed to follow. By General Assembly doesn't go into medical practice and say the AMA guides are all that's needed of you. But those AMA guides in litigation protect the doctor who's saying, I follow the best practices. So if the environmental interests who typically in farming and logging are saying these best practices protect you from environmental enforcement. I mean, this bill could say if you follow these best practices, then you're protected against environmental enforcement. That is what you do in farming and logging. You can see how going into tort is moving to new space. So I just want to be very, very clear. Show us the safety standards, the Vermont safety standards, before you expect us to then be able to really articulate to you in a thoughtful way how it doesn't play into the pocket move of going into tort law as an incentive to go through corporate chain. We very much understand the local and local truck is different than these corporate premises, but the law is the same. And it's, of course, we're going to show up. You know, customer service isn't what it used to be. Fox stores, people are watching their job. They're not helping people in the parking lot the way they used to. That generation's gone by. So, like, we're really on guard for safety. Thank you.
So, committee, we are gonna move on here in a minute to confirmatory adoptive bill and standby guardianship bill. We're gonna do some discussion for the government. Then We have that. That's it. The guardianships we're gonna be doing, and then DUI. Later, yeah. So we'll be doing the adoption bills and the guardianship bills. And then we'll be revisiting the DUI bill that we talked about yesterday. Was it yesterday or the day before? It's all like, yeah. And then we'll wrap things up, but it's just gonna be committee discussion. Michelle will be here any minute, I imagine. I think I just heard her voice.
And it's mostly modeled after.
And then just as a heads up, for next week, we'll be committing basically the first half of the week to hearing budget requests. There's around 8 people or 8 entities that want to have the 5 give their pitch, and we'll be putting together a letter midweek next week that embodies whatever our priorities might be after we get all those pitches.
Yeah. We would have been.
You have a second? I'd love to ask a question or give you information.
Okay.
Oh, sorry, adjourn. Oh, Michelle.